Welcome back to Introduction to Law. In Module 2, we're taking a look at the Australian legal system. And for this lecture, there are really two key things that we want you to take away. First, the structure of the Australian legal system. It's a reasonably complex system, so understanding how it all fits together is really important. Second, the power of the people in the Australian legal system. What I mean here is the relationship between citizens and the government. So let's get started. In your textbook, you'll see this graphic of the 7 key characteristics of the Australian legal system. What I want to do for this lecture is take things a bit further and look at the key characteristics, the most important and maybe more difficult concepts in the Australian legal system. And there are 4 of those: the common law system, common law legal system, the rule of law, separation of powers, and the Federation of Australia. And we'll go through each of these in turn. Starting with the common law legal system. Now, this is a system that Australia inherited from the United Kingdom. We call it a common law legal system because it places emphasis on the common law. The common law is case law. In a common law legal system like Australia, we say that cases make law. So when a case is decided in a court, that creates new law. This means that case law is recognised as a source of law in Australia, alongside legislation, which is law made by parliaments. We'll talk about that more in the next module. But for now, just contrast a common law legal system with what's called a civil law legal system. And a good example of a civil law legal system is France. In that system, the approach is that cases don't make law, they just apply legislation. The importance of Australia being a common law legal system is something that will really become clearer to you as we move through the course, because it's the foundation of a doctrine that you'll come to know and love called precedent. But we'll talk more about that in the weeks to come. Moving on to key characteristic number 2, we have the rule of law. The rule of law means that government power and authority should only be exercised in accordance with written, publicly disclosed laws. These laws need to be made and enforced in accordance with established procedure. If you do this, you get a gold star as a legal system. But established procedure is a bit of a loaded term here. So let's say we have a legal system where every day for the past 50 years, a king has been writing and enforcing new laws each morning based on what he dreamed the night before. There's a procedure. It's been in place for about 50 years, so it seems established. But this example is definitely not the rule of law in action. When we talk about established procedures in relation to the rule of law, we're also bringing in associated standards that those procedures have to live up to. Law needs to be properly made and enforced in fair ways. As for what that means, well, we're still not totally sure. Dicey standards for the rule of law, though, have been around for a long time and are a good place to start. So according to Dicey, the law should be applied equally to everyone, regardless of social status, culture, religion, or political beliefs. The courts should uphold the legal rights of citizens, including the right to personal freedom, and no person should be punished other than for conduct that is expressly made illegal. These standards, while they might seem very straightforward, are actually not so easy to apply in real life. When we're talking about courts, for example, what legal rights do they uphold, and how? Is the extremely high cost of legal proceedings in the US compliant with the rule of law? What about the availability of legal aid, free legal advice and representation, in Australia? In both cases, we're talking about access to justice. which is an important part of the rule of law. But how much access is enough? It's a difficult question, and sometimes it's easiest just to think about what the rule of law is not. If there is a jurisdiction where citizens can be imprisoned without charge, or imprisoned for political reasons, or on the whim of a person in government, that kind of thing is definitely not in line with the rule of law. It isn't a system where properly made laws apply equally to everyone, regardless of who they are. The third key characteristic of the Australian legal system is the separation of powers. In the Australian legal system, there are three arms of government: the legislature, the executive, and the judiciary. The legislature holds the law-making power. Through the parliamentary process, parliaments make law. Legislature is the parliaments. The executive is the administrative arm of government. It administers the laws that Parliament makes. The judiciary is judges in the courts, interpreting and arguably making law by deciding cases, because remember, we have a common law legal system. The important thing about separation of powers is that these different arms of government should be functionally separate. The reasons for this are pretty straightforward. Imagine if the government official given the role of administering financial grants, which would make them part of the executive, was also in charge of resolving disputes about the exercise of that power. Imagine they were also a member of the judiciary. That would be a very easy route towards abuse of process, to preventing oversight of decisions, to corruption, basically. We have separation of powers because each of these powers keeps the other in check. Every night on the news, you're probably going to see a story about Parliament engaging in oversight powers over one or more members of cabinet. That is responsible government in action, and it's made possible by the separation of powers. We get to this separation of powers in three ways: by trying to have separate people, or at least different roles, distinct roles for the different arms, by making sure that the different arms of government don't interfere or influence one another, and by making sure that each arm only exercises its own function. A complaint by some members of the executive and parliaments is that the judiciary is overstepping its role at the moment and becoming a bit too much like the legislature. Separation of powers requires functional separation. But that does mean that you will sometimes see the same people performing different roles. Separation of powers means separation of roles, but not necessarily separation of people. You can imagine it as though people are wearing different hats. So here we have Scott Morrison, the MP, part of the legislature, a member of Parliament, making law. And here we have Scott Morrison, the Prime Minister, the leader of the executive cabinet, who administers law. If you look really closely, you can even see he's got Prime Minister written on his hard hat. The fourth and final key characteristic is that Australia is a federation. That means we have a system with multiple layers, the federal level and the states. The route to understanding the Australian legal system, which, if you recall, is one of the key aims of this lecture, is to understand the Australian Constitution, because that really sets up the relationship of the different parts of that multi-layered legal system. So, a bit of background. The Australian Constitution came into force in 1901 through an act of the British Parliament, the Commonwealth of Australia Constitution Act 1900. And it is a substantial document. It comprises 8 chapters and 128 sections. The Australian Constitution established an umbrella government over the states of Australia. What it didn't do is set out a Bill of Rights. So the Australian Constitution is not a Bill of Rights. It's not like the United States Constitution. We can really contrast it with that. but it does grant some rights explicitly. So, grants the right to just compensation if property is acquired by the Commonwealth, grants the right to trial by jury, and the right to freedom of religion. On top of that, courts have also implied freedom of political communication and right to vote, including for prisoners, and they've implied that from Houses of Parliament being chosen by the people. This is an interesting point of contrast, really, because if we think about the UK, where there's no written constitution, there's also no right for prisoners to vote. So we can see the written constitution, even though it's not a Bill of Rights, having a real impact on the rights of citizens. The Australian Constitution sets out the Australian legal system, and it divides legislative power in that system into three categories. Exclusive powers, which are those exclusively held by the Commonwealth. Concurrent powers, those held jointly, concurrently, by the Commonwealth and the states. And residual powers, which are those held just by the states. And you see this set out in your textbook. If we look at exclusive powers, which are those exercised only by the Commonwealth, which we mean federal parliament, we see a few important powers straight away. Public service, the military, money, these are powers that sit exclusively with federal parliament. Then we have concurrent powers, which can be exercised concurrently, hence the name, by both federal and state parliaments. And these are set out in section 51 of the Australian Constitution. And there are some really important powers here. Just looking at this list quickly, we see trade, taxation, corporations, marriage, external affairs. These are important powers, and they sit in a fairly complex position because they're actually concurrently held by two different layers of the Australian legal system. So we need to unpack this concurrent idea a bit more. Well, it works like this. If the federal parliament has not legislated on the matter, then it remains within the authority of the states. But if a state has made law in relation to something that the federal parliament subsequently makes law on, then section 109 of the Australian Constitution kicks in. And that says, when a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. Courts are key to how the interpretation of these concurrent powers has been developed. Something you can see in the case law is reference to the intention of federal parliament. Did the federal legislature intend for the state and federal law to coexist, or did the federal parliament intend to be the source of law here? In which case, it's going to override the state legislature. And we can see this being discussed in the case of Ex parte Maclean. What this all means is that the federal parliament has the power to override the states, so long as they remain within their section 51 powers. Do you think states are going to like this? Because they do not. And this leaves the courts to try and mediate what's going to happen here, how this is all going to break down. Courts are having to deal with these disputes between states and federal parliament, with states arguing that federal parliament does not have the power under section 51 to make the laws it has. And generally, courts have favoured federal legislation by deeming it to override state legislation. In doing so, they've tended to give a broad interpretation of whether things fall within the scope of federal power. We saw this in the case of Koowarta and Bjelke-Petersen, when the Queensland government challenged the validity of the Racial Discrimination Act so that they could racially discriminate against Koowarta. The court, though, took an expansive interpretation of the external affairs concurrent power that the federal parliament has, saying that because Australia was a party to an international treaty prohibiting racial discrimination, the Act of Federal Parliament that supported Australia's compliance with that treaty was an exercise of the external affairs power. So the federal government had the power here. Commonwealth and Tasmania was decided in the same way, favouring the federal parliament by saying its acts were constitutionally valid as an exercise of the external affairs power on the basis of an international treaty. Now, the federal parliament doesn't always get its way, and in New South Wales and the Commonwealth, we saw the court interpreting Section 51 strictly, saying that while federal parliament had the power under Section 51 to make law regulating companies that had been formed, that didn't mean they had the power to make law regulating how companies could be formed. So we see the difference between, regulating companies that are already formed versus regulating companies that haven't yet come into existence and regulating how they can come into existence. Now, we can try and make sense of all of this by saying that an exercise of power is one thing, an exercise of an external affairs power is one thing, but an extension of power, as in the New South Wales case, is another. So whilst New South Wales looks like an extension, Kuata looks more like an exercise of a foreign affairs power, an external affairs power. Overall, what we've seen is an expansion of federal parliament power under Section 51. This is obviously at the expense of states' power, because it necessarily involves federal parliament overriding state parliaments. At the same time, the federal government has been issuing tied grants. These grants are issued to states on the condition that the state complies with federal government policies. And those conditions are what Parliament thinks fit. So they're much broader than the Section 51 powers. This means the Commonwealth, through the issue of these conditional tied grants, can effectively force states to comply with federal government policy if they want to keep their funding. And they can, through this, force states to comply in areas where the federal parliament doesn't actually have any formal power, whether it's exclusive or concurrent. So areas like hospitals, schools, education, that kind of thing. Finally, we come to residual powers. Anything not expressly identified as an exclusive power or a concurrent power falls to the states as a residual power. They include powers over education, health, the criminal law, contracts, torts, property, transport, lots of other things. Lots of really important legal areas, which can all be different from state to state. Maybe you're starting to get an idea here of how this might make lawyers' lives slightly more complicated. States have a part to play, definitely, in the Australian legal system. And they also have their own constitutions. And what I recommend doing here is going and looking at your own state's constitution. I'm just giving you a guide to the Commonwealth Constitution, the Federal Constitution. How does your state compare? Because state constitutions have a reputation for being really convoluted and quite complex. But I want you to go and see if that's justified for your state. And the easiest way to do that is to find your state's constitution right after this lecture and see whether you can understand it. Because if you can't understand it, then maybe we have a problem that goes back to the rule of law. If you can't understand the law, then how is it going to be fairly administered to you, on you, as a citizen? And that brings us quite nicely to the power of people in the Australian legal system, and the balance of power between those people, citizens, and the executive. If a person is unhappy with the decision of the executive, then they have a few options. There are multiple ombudsmen for federal decisions, for state decisions, things like that. And a citizen can complain to an ombudsman and request that they investigate an administrative decision. What the ombudsman will generally do here is look at the process through which the decision was reached. That's to provide oversight over whether the executive operated fairly, whether it followed its own rules. The Ombudsman's not generally there, though, to provide their own decision on the matter. They're just providing oversight over the process and whether the proper processes were followed. Another way for citizens to hold the executive to account is to get information. Access to information is essential to accountability because you need the information on which to hold the government to account. Right to information, or FOI requests, mean citizens can see the basis of executive decision-making. Interrogating those bases and the reasoning of the executive is an important part of challenging executive decision-making. If you've heard the saying, make bricks without straw, well, in a law course, we like to challenge the executive only with metaphorical bricks, never real bricks. And the straw is the information citizens can get through freedom of information, right to information requests. Administrative appeals tribunals operate in most states and in the federal government. They exist as a means of appealing administrative decisions, but they are not courts. They exist as part of the executive arm of government. What these tribunals do is look at government decisions and they decide whether the policies and rules have been followed and whether the right decision was made as a result. If the tribunal doesn't think the decision was right, then what it can do is substitute that decision for its own. The tribunal doesn't just send the decision back to the executive for a second look, it makes its own decision. It can do that because it's a part of the executive. And we can contrast the position of the Administrative Appeals Tribunal with judicial review. Judicial review is the process of going to court to seek review of an executive decision. The outcome of this can be the court telling the executive to do something or to refrain from doing something, and this is called a prerogative writ. What the court is doing, or what it's ordering, depends on the type of writ. So it might be an order to bring an imprisoned person to court to ensure that they're heard. It might be an order that an administrative officer perform their duties or provide a record of their decision. Or it might be an order prohibiting the executive from exceeding its powers. The details, as well as the correct pronunciation of certiorari, are things that you'll cover in administrative law. So right now, all you need to know is that these powers exist. What a court can't do in judicial review is substitute its own decision on the matter. Courts are part of the judicial arm of government. They are not an administrative body, they're not part of the executive, so they can't make administrative decisions. That's the purview of the executive. Remember the separation of powers, courts have to respect this. And that's about it. When it comes to reviewing your notes, consider the balance of power between the Commonwealth and the states, and between the government and its citizens. Importantly, try and be critical here. What do you think about this balance? Is it correct, or is something off? Think about what you would change in these systems. Thanks for listening.